I'd like to call the meeting to order, please. Before we hear the first case, I have some guidelines to read. This is a public hearing, and we are the Zoning Board of Adjustment for Putnam County, Florida. We operate under the authority of Articles 11 and 12 of the Land Development Code as amended. The primary responsibility of the board is to hear and decide appeals challenging final determinations made by the Planning and Development Services under the Land Development Code, and to hear and act upon requests for variances, special use permits, non-conforming use determinations, and preliminary development plans under the Land Development Code. Today we have a variance, so I will read that section. A variance is a relaxation of the requirements of the zoning code in a particular case where, because of unusual circumstances, a little enforcement of our zoning code would result in undue or unnecessary hardship. The zoning code permits us to authorize variances only for height, size of structure, size of yards, and open spaces. If we grant a variance, we may impose reasonable conditions on the use of the property, which must be satisfied if the variance is to remain valid. The standards we use in deciding whether or not to grant a variance are listed in Section 45-833 of the Land Development Code. Procedurally, we will call each case by name and number. A member of the staff will then briefly explain to us the nature of each request. We will then take any comments from the applicant or their representative, followed by any public comments concerning the request. Please direct all comments and statements to the board and not to other people in the audience. Before speaking, we will ask each person to be recognized, come forward to the lectern, and identify his or herself by name and address. After all persons wishing to speak have been heard, we will entertain a motion from the board. This motion will be voted on by the board members and become our final order. Any decision made by this board can be appealed to the circuit court. However, any appeal must be filed within 30 days after the Board of Adjustments has rendered the final order which is being appealed. Are there any questions? Before the first case is heard today, all of those wishing to speak will need to be sworn in, so will the notary please administer the oath.
Conflicts of interest.
As soon as she gets...
Do you swear or affirm that you will tell the truth in your testimony? If so, please answer, I do.
I do.
Thank you. You may have a seat. You've been sworn in.
Okay, before we hear the first case, we need to do a roll call for ex parte communication or conflict of interest. And this variance 25-00008.
Mark Fisher,
No.
Ron West,
No.
Linda Osborne,
No.
Willie McGahee,
No.
Hunter Winkleman,
No.
Dan Dodge,
No.
Cole Wilkinson.
No.
Okay.
Very
Staff,
well.
we're ready?
Yes, Madam Chair. We shall begin with variance 25-000008. For the record, Michael Graves, Planning and Development Services. The applicants are Thomas and Laurie J. Leonard. The location is 126 Lake Como Point Road in Pomona Park on a property that is approximately 6.74 acres in size, though only 1.4 acres of that is actual land. The property is zoned residential 1 with a future land use of rural residential. The variance is to allow for a reduction in the front setback from 25 feet to 3 feet, a total of a 22-foot reduction of the front setback for a residential 1 property to build a single-family residence. The applicants are requesting the setback reduction to build a new, larger home on the property and replace the existing home. The lot is of a unique nature and shape, being a peninsula, which there are not very many of in Putnam County. It is not part of any recorded or unrecorded subdivision, and it was rezoned as of last year to establish uniform R1 zoning on the property for reduced setbacks, as before it was partially in the agriculture estate zoning district, which had higher setbacks. Here you can see the aerial. The property itself has an odd configuration, and the land has an even odder configuration within the property, as you can see. Here you can see the old zoning map where we had the agriculture estate and the R1. The green area in this property is now as yellow as the rest, meaning it is now residential 1. The future land use, as you can see, it is rural residential. The FEMA flood zone, you'll note that the entire property is in a special flood hazard area, meaning any development will have to apply with FEMA regulations. And the wetlands, staff do not believe this is indicative of actual wetlands on the property. Rather, the GIS map tends to say that any body of water is jurisdictional wetlands. There are criteria for variances that need to be met for the granting or denial. Criteria number 1 is that special conditions and circumstances exist which are peculiar to the land, structure, or building involved. The unique peninsula shape, as well as the limited above water land being 1.4 acres, renders special circumstances onto this land that is not commonly seen throughout Putnam County. Number 2 is that the special conditions and circumstances described in the previous condition do not result from a failure of the applicant's part. The applicants have attempted to remedy the issues with the land, as mentioned before with their rezone from last year. There is technically enough buildable land without the need for a variance. However, the amount of land available is greatly diminished from the theoretical maximum for an equally sized property. The loss of buildable land is not the fault of the applicants. Granting the variance will not confer special privilege to the applicants. Granting this that is criteria 3. Granting of the variance might be considered special privilege due to the LDC wording about a 10-foot setback from the lot line. However, there would still be general compliance with the LDC despite the significant amount of reduction, as the 22-foot reduction is from the end of a 10-foot wide easement on the property. So they will still be 12 feet from the actual property line itself. Literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district. This is criteria 4. Literal interpretation is unlikely to place undue hardship on the applicants. Property rights are protected in Putnam County. Denial would require the alteration or reduction of the home that is not supported by the comprehensive plan or the land development code. However, a home could still potentially be built on this property. Granting of the variance will be in harmony with the general intent and purpose of this ordinance and the land development code. The granting of the variance will be mostly in harmony with the general intent and purpose of the land development code. It is unlikely that the reduction of the front setback shall cause danger to the applicants or the area. The fire marshal has made comment that the development should not cause any undue risk to the area. The variance granted is the minimum necessary to make reasonable use of the land. This is criteria 6. The requested variance is not necessarily the minimum possible to make reasonable use of the land. The variance would, however, provide relief from construction restrictions due to the unique characters of this property that would otherwise be hardship, more or less. It is because of all this that staff finds that the requested variance meets the majority of the criteria for the issuance of a variance in the Land Development Code, section 45-833. Staff gives the recommendation of approval of the requested variance to allow a reduction from the front setback from 25 feet to 3 feet, a total of a 22-foot reduction on a 6.74 acre residential 1 zone property with the following conditions. Condition number 1 is that the variance shall apply only to the main residence of the property. All other structures shall comply with the setbacks of this property for the zoning district. Condition 2 was requested for a small amendment by the applicants. Initially, staff had said a new easement depicting a 40-foot radius cul-de-sac shall be recorded and dedicated to Putnam County within 80 feet of the intersection of the eastmost property line and the front property line, subject to the current easement. The applicants have requested that be changed from radius to diameter, 40-foot radius to 40-foot diameter. Condition number 3 is that in accordance with Land Development Code section 45-403, 3A, The on-site sewage system, be it septic tank or otherwise, shall be relocated a minimum of 100 feet from the mean or ordinary high water line if it is not already located as such. The applicants have also made comment with staff that they wish to discuss this condition in particular with you, so I will turn you over to them in just a moment. And condition number 4 is to ensure further protection of the lake this property is located on. The applicants, owners of the property, shall comply with all regulations in Land Development Code Section 45403, including subsections 6 and 7, which further limit development in the waterfront buffer and require all such developments be designed, constructed, and maintained in a way so as to minimize the adverse effect on the shoreline protection zone. Any questions?
Questions for staff? Okay, thank you. Okay, before we proceed with the case, let's do a site visit roll call, please.
Mark Fisher,
Yes.
Ron West,
Yes.
Linda Osborne,
Yes.
Willie McGahee,
Yes.
Hunter Winkleman,
No.
Dan Dodge,
Yes.
Cole Wilkinson.
No.
Okay, the first case today is variance 25-000008, and we have an agent, Jennifer Wilson. Would you like to come forward? Please state your name and address for the record.
Good afternoon, Jennifer Wilson, 42.
Probably need to lift that up.
There- Can y'all hear me now?
Yeah, it's better.
Jennifer Wilson, 4201 Bay Meadows Road, Suite 3, Jacksonville, Florida, 32217.
Okay.
So I am here on behalf of the applicants, Mr. and Mrs. Leonard, and they are, again, to reiterate, thank you very much, Michael, for your staff report, reiterate that they are requesting a variance for the front setback in order to build their new home. And I'm sure many of you are already asking, why such a big home? Well, they have a family of almost 20. The Leonards have been visiting this property since the late 70s, and it's always been his desire to have a home where the entire family, grandkids, and everybody can run around, enjoy the lake, and have a good time. So to fit that many people, as any of you have ever vacationed with family, y'all understand what it's like to have that many people under one roof. As Michael mentioned, we do have some discussion regarding the conditions, and I have an example. We are perfectly fine with the conditions as they stand independently. However, there is a little bit of a conflict with number 2 and number 3 as they are written. Number 2, we completely understand the need for an easement to give EMS, waste management, and everyone access to be able to turn around in case there was an emergency or get out on the road. Not a problem with that one. However, the setback at 100 feet from the mean water line of this property, because it is a peninsula and such an unusual configuration, 100 feet from the property line for the septic system is almost impossible unless it is situated directly in the middle of where they are proposing the home. By state law, Florida FAC 62E, the state allows for a 75-foot setback from a mean water line. That is also listed in Chapter 381-065, where it's allowed for a 75-foot setback. If you guys will allow me, our team drew up an approximated site plan showing.
Wait, okay, don't talk other than from the mic, so whenever you pass those out. Thank you. Whoops.
You guys don't have to share it. Sorry, I didn't put it enough. As you can see, we're showing the restrictions on this property. You've got wetlands, you've got wetland buffers, you've got mean high water lines, you've got a front lot setback that which we are trying to avoid whatsoever by means of this variance. That's another reason we're asking for such a large reduction, so we don't encroach on the water line. The only place to put that septic tank is where that little red triangle is, to kind of the southwest property of the house, and that's at 75 feet. The only way we could meet 100 is to show exactly where that little easement is going to the very east end of the property to the right. So unfortunately, we're at a little bit of a conundrum right now to make both of those conditions work together.
Have you guys discussed this with staff prior to now?
We discussed it with Michael yesterday and today. I just got the agenda yesterday.
There was only a brief email discussion. As far as staff is concerned, this is part of the land development code still, where the land development code says that it has to be 100 feet from the mean high water line. Staff doesn't necessarily have any leeway themselves, as the boards would, to make alterations to land development code, or in other words, grant variances. When it comes to health regulations, which the septic and well is definitely more health than it is zoning, that is generally handled more by the state agency rather than the local agencies. Quite frankly speaking, if this was any other property, we may not even have noticed something like this, just because the chance of a peninsular property which has this very odd configuration would go mostly unnoticed for these more obscure parts of the land development code, which all people are still bound by. Staff doesn't really have any consideration for this one way or the other, unfortunately.
Madam Chair. Mr. Graves, can you pull up on the screen so we can all look at it together? I just had one concern on the site plan she just handed us versus what we saw in the application. Similar, but the site plan map showing topography survey of a portion, it was a DRMP at the bottom right.
You'll have to give me a second to pull
Take your
up the-
time. It was in the agenda packet that we got. It was a site plan drawn by I'm guessing a contractor they hired to do a site plan. Is that correct? Do you see that, Michael?
So I don't actually have access to the site plan.
Oh, you don't have access to the site plan. Okay.
No, sir.
I'll ask. You're on behalf of the applicant, ma'am. Is that correct?
Yes, and
So the site plan you just gave us, a concern I have is on the location of. First off, where's the location at for potential future potable well, or is there one there on there currently? Already a potable well on the property?
yes, there's already a potable well.
And
on
where's
there.
it located at in relation to that septic tank?
I've got a copy of the survey here, but honestly, I don't know that I could
Yeah.
put it on an 8.5 by 11.
If you, in our packet, we as board members received a site plan, and you definitely have it. You submitted it. DRMP drew it at 123 Lake Como Point Road. They reflected that there was a well within 5 feet of the property line. It looks like you're going to be really close on that setback on putting your septic where you want it, because you have to be 75 feet, not only obviously from your own well, but also from any neighboring wells. So it was drawn by DRMP. I'll see if I can find you a page number. It's in the application you submitted.
This one?
Yes, I believe so. Yeah, if you look in the
That's a
bottom,
copy of the survey.
that's a copy of the survey. Okay. If you look in the bottom right-hand corner on that said property at 123 neighboring, you'll see there's a well located within 5 feet of said property line. Do we have enough setback off of that as well, off any neighboring wells as well?
I honestly cannot answer that. Like I said, we just got the agenda yesterday
Gotcha.
and we're informed of these conditions.
I'm
So-
sorry. You go ahead, ma'am.
So we were kind of scrambling to put something together.
Understood.
There is a possibility, again, to relocate the septic tank a little bit northeast or a little bit north of the proposed easement. Again, if we can go to the state-regulated 75-foot restriction.
And I'm in agreement with you, 75 feet, 100%, but that includes obviously any neighboring wells also.
Right, yes,
So-
sir. We are the engineering firm.
I got you. Okay,
The
cool.
civil engineering firm, so we are
You
pretty
can measure,
familiar
you can make
with
measurements
all
off all that. Okay.
well, septic. The owner is also proposing to do one of the new AWTS systems,
Okay.
which reduces influent, reduces footprint, has a smaller drain field, doesn't have the huge mounds or anything like that. It also adheres to DEP's nutrient removal rules that was introduced last year.
So I just
There's
looked,
environmentally less impact with the new systems.
I didn't mean to interrupt you. I apologize. On that survey copy, if you look in the, it would be the directly east portion. So it's on the point into the house, on the lawn side of the lake. You'll see it says pump house with well. So that's directly opposite of the septic. The problem is, again, like I said, the hang up that I really want to get answered is what is our setback going to be at 123? There was a well constructed there in 2017, and if it is that well, that is their potable well according to records of intention. So I think we need to get that answered before we approve this of any type, because we're ultimately giving the applicant the ability to place a potential septic tank within boundary lines that would potentially conflict with a neighboring well.
Which we would make the application through the state, through the health department, to
Okay.
make sure that all of those conformed.
Perfect.
Okay.
Madam Chair,
Yes, Mr. Dodge.
thank you. Where is the current septic system located on the site?
Again, please forgive me, my eyesight is not what it used to be. It is actually roughly about here.
You're far away. Could you come
Yeah.
closer, please?
I should have brought big sets.
Thank you very much.
I believe it is located, I think my engineer might have called it out here. It is roughly, I don't think it is, I think it's roughly about here right now, which does not conform to the 100-foot setback now.
Oh, sure, does it the 75?
So it's immediately off to the side of the house.
Okay, we need to have this discussion to where everybody is privy to what is being said.
Can you show the others the location, please? Miss?
The location of the
Oh.
well as it exists now is roughly right here.
Miss, my question was the septic, not the well.
I'm sorry, I mean the septic,
Okay. All right.
which is non-conforming to the 100-foot now, but it's been there for some time.
Does the current septic site conform to a 75-foot back?
No, sir, it does not.
And the current home was built, I believe, in the mid-'70s.
Yes, sir, that's correct.
I assume that's the age of the existing septic?
Yes.
Okay. I was trying to say, don't ask people in the audience.
Sorry, it
we
was
can-
the
we can
homeowner.
address that.
How many bedrooms does the current home have?
Can I ask the owner that question?
Okay, ask, how
Sorry.
many bedrooms does the current house have?
3.
Okay, thank you.
And how many bedrooms the proposed home?
5.
Thank you.
Yes, Madam Chair, I believe you're correct.
I got the signal from them. Okay, Mr. Baker, Zach, would you like to chime in here? Because if they're having an issue with the 100 feet setback, and would we have to have a new condition, or does that not correspond to the comprehensive land development plan?
So it's my understanding and perspective that if a state agency is the regulating and permitting authority for a specific attribute such as septic location, if their restrictions are, or if their regulations are less restrictive than ours, I don't see how we would really have a defensible argument if it were to ever be appealed or challenged, because it's ultimately the state that establishes the regulations for septic requirements. So we can have something locally that is more restrictive, but at the end of the day, if DOH is willing to approve that septic system, I have a feeling that a 75-foot from the ordinary high water line would be sufficient. Anecdotally, I attempted to challenge this when I was a young planner, and I was told to leave it to the state agency.
Okay, so it would just have to be a revision of a condition then, that's on this, as far as 100 versus 75.
Yes, ma'am, so ultimately, because DOH is separate from Putnam County, when a building permit comes in, we just look that they've gotten their approvals from the Department of Health. So there's no telling how many septic systems are spread across Putnam County that are within 100 foot of the ordinary high water line. And I think that it would be disadvantageous for us to impose it on this property for the simple sake that they are going through this variance process, when knowingly we haven't imposed it on any other waterfront property to my knowledge.
Okay, well, so it can be revised then, as far as, should it be revised as far as the statement, since it's one of the conditions in our packet, as far as approval?
I mean, so ultimately, I think it would be up to this commission as to whether or not they wanted to keep that condition or omit that condition. If you all agree with the 100-foot requirement, and I'm not so it does say shall. I presume that this language is taken directly from the code.
That is
So
correct.
it does say shall, which, you know, in legalese means you will do that. But again, given that this is really truly a state's legislation, I don't really see how we could make them do something that the state is not going to make them do.
Well, I understand that too, but I'm just curious, because in the condition it says 100 feet. So as, when we make a motion, do we need to change that to say 75, or can we leave it like it is at 100?
It'd be up to the board
Okay,
for you guys to determine when you discuss. I believe you'll probably also be discussing condition 2, which staff has recommended a 40-foot radius, and the applicants and agent are recommending or requesting a 40-foot diameter.
Madam Chair, couldn't we also state, subject to the Florida Department of Health regulations,
we
instead
could.
of being specific?
You could do that as well.
That satisfy?
That would just have to be part of the motion then. Okay.
If
All right.
if I may, condition 4 does also come into effect here, since condition 4 is saying that they'll comply with all parts of 45-403, and condition 3 is a subsection of 45-403. So just to make sure that there isn't any legal headaches or anguish later, it may be best to say 75 feet or the Florida Department of Health regulation as an amendment to condition 3, as opposed to just removing condition 3.
Okay,
That way we don't get caught on condition 4 saying the same thing again, essentially.
We are perfectly okay with that.
okay, Ms. Wilson, you can continue, or are you done? You have some more?
I think that's it. I
Oh,
think
okay.
I've talked enough. Any other questions?
Any other questions for Ms. Wilson? Okay, thank you very much. Okay, we have some speaker cards today. Mr. Tom Leonard, I think, is the property owner, so would you like to come forward and address the board? Give us your name and address for the record.
Hi, Tom Leonard. The Putnam address is 126.
Okay, you're going to have to raise your
Yeah.
mic, because I can't hear you.
Yeah, Tom Leonard, 126 Lake Como Point Drive here in Putnam County, and then in Jacksonville, 12905 Bay Plantation Drive. I think, I appreciate you guys considering all this today. I would comment for the group here. I've actually been coming to Putnam County and this lake specifically for 49 years. I was invited by a high school buddy of mine back in 1976 to come, vacation at his family's property on Lake Como, and did that for a long time. Then got married and brought my kids down here for 4 years, or my 4 kids down here. My buddy's family have bought property on the lake, and we've just, as a big family, extended family, been enjoying the lake for a long time. As my Jennifer said earlier, my children have, I now have grandchildren, 6, 2 on the way in the next few weeks, and I'm sure a few more after that. So we've got 18 people to have a family gathering, and thus the desire to build a bigger home that can accommodate all of us.
Okay.
What else? And I think, the variance we're asking, the existing home that's there, the proximity of that home to the property lines is no different than what we're asking for in the variance. There's just new rules, obviously, over time. The septic tank, as you asked earlier today, is in a place that's not within those limits. So we're willing to, use the newest, latest technology, put it within the new limits of the 75 feet, and create the easement for the public, the EMS services, et cetera.
Okay, any questions for Mr. Levitt? Thank you, sir.
You bet.
We have another speaker in favor today, Brian, is it Baldwin? Please state your name and address for the record.
Brian Baldwin, Lake Como address is 120 Lake Como Point Road, Lake Como. I also live in Jacksonville. So I have a home that's 2 lots over from his, and I've known Tom since early 80s. I've had the house in Putnam County, Lake Como, since '89. I'm in the same boat as he is, not quite to his extent of having kids and grandkids all raised down here. And that's why we have homes down here. So I'd like to be in the position where I have to build a bigger home, which my house is minuscule compared to his, and probably have to go and cheat off his house at some point in time. But I don't think the variance is an issue considering what he's trying to do with the house. I want to see the house. I think it's going to be beautiful. My kids will play with his kids. Well, my grandkids will play with the kids. So it benefits us, and that's why I think it's a great idea. So,
Okay.
any other
Any
questions?
other questions? Okay, thank you, sir.
Thank you.
Okay, I only have 2 speaker cards in favor, so anyone else wishing to come forward and speak in favor? Okay, I have 1 card for opposition. John McKenzie, please come forward.
John McKenzie, 123 Lake Como Point Road. The address.
Okay,
He's my neighbor.
okay, well, you need to speak up so we can hear.
Okay, 123 Lake Como Point Road. John McKenzie is my name.
I got you, okay.
And what is my objection?
Yes,
I bought my house about a year before he did, and we had it surveyed, and the survey showed that my property went 2 feet into his house. A year later, he bought the house. He had a survey done, the same results, that the property line was 2 feet into his house. Recently, he had it resurveyed, and the survey brought it about 10 feet closer to my house. And I don't know, and I asked the surveyors, how could that happen? And they said they started from the other side of the property or something, and then it moved the property line to the left of his house. And I said, that's okay. But he's going to build like a 6,000 square foot house on the point, and he wants it to be 3 feet from. Like I don't understand how you I don't think he's recorded the survey. I have the surveys here if you want to take a look at them.
we're not official
Okay.
survey.
And so he had it resurveyed. So I don't know if that's correct or not. I don't know. It hasn't been recorded here in the county, and so there's a discrepancy between the property line, my owner property line, and his. And for the 20 years that we've had the houses, I said it's okay, I can live with that. And but now he wants to build this big house, and he wants to build it. Here's my, his house is here. There is a survey marker in the driveway that he now contends is his property line, and he wants to build the house 3 feet from that, and that's just really close to my house. He's offered to buy pieces of property from me, but my wife doesn't want to sell it, and I don't really want to sell it. So I object to that. And I also didn't know about the septic system, but I think he designed the house before he looked at the land, and he should have looked at the land first and then designed the house. One of the solutions I'm thinking is that if he builds posts, like has concrete pillars put into the flood zone area, he can still build his house and have it further away and put the septic possibly under the house because it'll be up off the ground. So anyway, I object because it's just too close to me, and then his septic system is pretty close to my well. I had my first well ran out of water, so I had another well put in, and it's probably 75 feet from his septic system. But if he does what he wants to do, it's going to be even closer. His septic will be closer to the way you were talking about that earlier. I didn't have that as a concern before, but now I do. So I object to the 3 feet of variance. It's too close to my house.
Any questions for Mr.?
I have one question. You had, in the reference to your whole survey issue, there was a boundary line agreement that you signed in 2006. Was that on the same piece of property that we're in reference to?
When I bought the house from the house that he owns now, I bought it from the original owner. Her husband developed that point there. When we had it surveyed, she signed a paper stating that, she's accepting that the property line is in her house and that we wouldn't make her move their house or do anything like that. So, and I was okay with that. And then he bought the house a year later, and they had it resurveyed, and it was the same situation, and I'm okay with that. It's probably from where his current, where he said he had it resurveyed. There's a marker, a metal marker there, and his house is probably 10 feet away from that marker, and I don't want it to be 3 feet away from the marker. Even I'm okay with that. I don't really understand it, to tell you the truth, about the survey part. So he said he had it resurveyed, but it's not filed. So who knows, I don't know what to tell you. I don't understand it.
I have one more question for you. On the survey I'm looking at, your new well is located where in relation to your property shaped like a piece of pizza or like a triangle?
Right.
Is it closer to his house? Is it closer towards Lake Como Drive itself? In which direction is it located on your property?
Well, his house is here. The property line goes down like this, and my house is here, and it's about probably 5 feet from the property line closer to the lake.
Got it. So your well is located directly adjacent to his property line, 5 feet off, the new one you had constructed?
Correct.
Okay.
Any other questions?
So I think he should redesign the house to fit the land, and then they can put the septic system probably under the house. And it can retain so I'm willing to go 10 or 15 feet from the property line, but not 3 feet. It's, and plus there's a, who knows actually where the property line is. According to these two surveys, it's 2 feet into his house, and then there's another spot that's unrecorded that's nobody owns. And when he bought it, he said, well, what do you want to do with it? I said, well, just leave it alone. Just split it, So that's how it's been for the last 20 years.
Okay. Mr. Dodge?
Which property line is it that may have changed?
Well, his house is here. His house is here. If I could show you on a piece of paper, it's a lot easier.
Sure, for you.
Want me to
Want
show
use
you on
this?
here? Yeah.
Madam Chair, I don't know about communication happening without him at the mic. Is there any way we can pull that up?
Yeah, I was going to say, you can't.
And can Mr. Graves, can you allow him to have a screen? And Mr. Dawes, should you look at your screen and use the same?
Sure, thank you.
Sorry, screen?
Yeah, is it that we can?
Is his screen up, or can he use your screen to show the individual what he's referencing, Mr. Dodge?
I don't believe there's a way for the staff grant you screen. IT is shaking their head no, so I would have to assume the answer is no.
Well, then I think the best bet would just give him the...
This map survey shows what... My house is over here. Here's his house. This is the correct property line goes 2 feet into his house.
If you'll turn your attention to what is on the screen right now, the shared property line is the side property line that's on the southern end, the one that's kind of in the rectangle on the east side there.
So it's the property line on his property that makes up the left of the triangle,
Yes.
correct?
That would appear to be the case, yes, sir.
Thank you.
Staff, I have a question. Do you guys look at the most recent survey to determine the boundaries and where the property actually
Whenever we do any variance, special use permit, development review committee, any application by any applicant, we use whatever survey is provided by the applicant. We do not use older surveys, as most of the time we don't have older surveys. So we only use whatever documentation is provided to us.
Okay, so what is the most recent date on that survey?
I could not tell you off the top of my head. I would have to turn you over to the applicant's agent again, as they were the ones to provide us that documentation.
Madam Chair, if I may. If I may. The survey that Mr. Winkleman cited earlier, the map showing topographic survey that was completed by DRMP, is dated February 27, 2025.
Okay. And that's the survey that you used as far as to determine the boundary lines and stuff?
Well, I would turn that question back over to Michael, but I presume that this is the survey he used.
That's correct. We used that and the boundary survey that they provided, which was in the same packet. It should be in your staff report.
Okay. And when was your survey completed?
One is, mine was done in 2005, and his was done in 2006. And they were the same results. He just had another survey done, and then he said he had one done from the air. Is that right, Tom?
Turner, Ms. McKenzie, talk to us.
Okay. Then he told me that he had one done from the air. I don't know how he did that, but there's a conflict in the survey, that survey and this survey. So I don't know if his is certified. Is it registered? Mine is certified and registered. And the point is, I just don't want him to be 3 feet away from. I'm willing to go to where that, where it currently is on that map. Where on his survey, there's a marker that was there when I bought the house, and that's all. Well, I always thought it was the real one, but these two surveys say no, it's not.
Okay, correct.
Madam Chair.
Did you say the survey was done in 2025?
Yes, ma'am, that is correct. The one that's in
Most
your
recent.
packet was done February 27th, 2025.
Okay.
And I talked to the surveyors who did the survey, and I said, well, how could you move that? And they said, well, they started from the other direction.
Okay, we can't get into how as far as the surveys were conducted. That's not what we're here for. So if there's any issues with the survey, that's something that we don't have anything to do with. So, as a
Madam
board.
Chairman, may I make a comment?
Yes, sir.
And it's Michael, I'd like your opinion on. When I look at the proposal and see the existing structure compared to the property line in question, and I look at the new proposed structure, it appears that the new structure building outline is further away from the property line in question.
That is correct. What it is the road, the Lake Como Point Road. It is a private easement. That means whenever we are dealing with the front setback, we take it from the edge of the easement. And it is a 20-foot wide easement with 10 feet both on the applicant's property and on the current commenter's property. Because of that, the setback reduction would be from 25 feet from the edge of the easement down to 3 feet from the edge of the easement, which would mean that they would still be 13 feet away from the actual property line, at least according to the survey.
I'm okay with that.
And in fact, the new structure is further away.
Correct. The currently existing structure, if memory serves right, is approximately 4 feet from the side property line, which has a normal setback of 10 feet. So they would be technically, they would no longer be encroaching on the side setback, they would only be encroaching on the front setback, and they would still retain 13 feet of distance from the actual property line itself.
Okay. So if you look on your survey there, you see the house, and then there's a driveway or a concrete slab,
Yes.
and the property line, the new property line from 2025 is right at the edge of that concrete slab.
I see that, sir.
So his house isn't going to be 3 feet from that. It's going to be 13 feet from that. And basically, the house is going to be in the same place it was before.
More to the north, but that appears to be correct.
Okay, I'm okay with that. Let's-
One other thing that I think is pertinent to mention is if Lake Como Point Road had been a public county-maintained road as opposed to a private easement, then this variance would be the equivalent of asking for a 12-foot setback reduction as opposed to a 22-foot setback reduction. We quite frankly wouldn't even be here. It would be done administratively.
Okay.
So
Any-
rest assured that from where his new property line is, it'll be 13 feet that way. Because I always felt weird, like my property's 2 feet into the house, I don't want to go in his driveway, I don't park in his driveway, and, I'd always left that alone. But if it's 13 feet away from that, I'm okay with that.
Okay.
And that's the case.
Any other questions?
No.
Okay, thank you, Mr. McKenzie.
Madam Chair,
Yes.
I have a question for staff and for Zach. Zach, what's your take on the comment about this is a easement and not a county-maintained road, and then the requirement of us making them have the cul-de-sac at the end? I mean, does that weigh their way if it was a county-maintained road versus if it's a cul-de-sac or if it's an easement? You have any feelings about that?
So I guess the best way to answer your question is if we were to see a new subdivision, whether it was a recorded subdivision or an administrative subdivision, we would require the applicants to provide a cul-de-sac on that property. And ultimately, it's for EMS, fire, rescue vehicles to access the property and perform a turnaround maneuver. But at the end of the day, if there's a fire or an emergency at the end of that road, they're going to go to that emergency. So the easement is a requirement of the code, but also our firefighters and EMS folks, they don't know where that easement is located when they get to the property.
Okay. Any other questions?
Where did the number come from we're requesting a 40-foot radius and they want to do 40-foot diameter? Where did our number come from? Did it come from EOC?
So the 40-foot radius is a requirement for driveways serving 2 residential structures. If it was like a road, then all we require is a 66-foot wide right-of-way and an 80-foot diameter in terms of the right-of-way that is conveyed, not the improved area.
Any other questions? Any other questions for staff? Okay, thank you, Mr. McKenzie.
Thank you.
I'm going to give the applicant a chance to, if they want a rebuttal of any kind, to come back and address the board, or are you satisfied with the way things? Okay. Okay, so, don't,
Just to
wait,
clarify.
wait till you get to the mic so
Yeah,
we can have it
sorry, Tom
recorded.
Leonard
So
again.
let's, your name, please,
Yes,
again.
Tom Leonard again.
Okay, we need, I'll have a difficulty hearing today. I don't know if
I
I'm
am
deaf
too.
or what, but the system,
All right, I'll speak up. Oh, there we go. Now it's working.
there we go, that's
Okay.
better.
Tom Leonard, the applicant again, and I just wanted to reaffirm what Michael said. The 3-foot setback is from the 10-foot easement, so the distance from the property line is 13 feet.
Okay.
Right?
Talk
He's
about
finding acceptable. And the new home will be actually no closer than the existing structure that's already there. So it doesn't sound like we have an objection from a neighbor at this point. So it is confusing. It took me a long time to figure it out, the distance from a property line versus distance from a private easement. And then I guess the only other comment is just, hopefully we all can work together to figure out the septic. I mean, I want to put in the most advanced, most capable system. We just have to find a place to put it.
Okay. Thank you. Any other questions for Mr. Leonard? No.
I have a comment, Madam Chair, I'd like to make to Zach. Zach, where I'm at on this is on the septic issue. I know that we've leaned back on the fact that this is a state issue with the 75 feet, but in our mission statement, it does say that we're to create undue hardship on other individuals. And the gentleman directly next door at 123, based on this site plan, unfortunately, we don't have a measurement showing that. My issue with that is, yeah, it all falls back on the health department, but ultimately, if, let's say we approve this variance, and then they get down the road and the health department says, I mean, because according to the site plan, that is not even close to 75 feet from the neighboring well. Now we've approved a variance, we've made it conforming, but now they have to go through a whole nother step of processes like a potential variance from the state, which being in that field, I can tell you is very rigorous and it is not fun to do. I'd like to see, in legal, you could tell me if I'm wrong, Mr. Perry, if I don't like to overstep our bounds as a board, but that could potentially create an undue hardship on the gentleman next door, because now he's being kind of included in this issue because we allowed this variance to occur. We're pretty much agreeing to this site plan and saying, well, yeah, we said they could put it there, even though DOH says, well, now you can't meet your 75-foot setback off of existing wells, which is what I'm concerned about, along with the high water line too. But existing wells, it's a 75-foot setback minimum. There's not a lot of vertical separation, so horizontal separation across the ground. The vertical separation to the aquifer there is only around 70 to 90 feet, give or take, depending on where you're at on that point. So ultimately, you know, our line is you're getting real close to a potential open source of water. I wish that in this we had something that showed reference points to setbacks from septic tanks to neighboring wells also, because of how tight these lots are. Because according to the survey done that was in our packet, it's tight. I mean, I don't have a measuring or a ruler to do a, you know, scale to measure, but I'd be willing to bet that it's less than 50 feet where the proposed septic is, because the existing septic is pointing off the front of the existing house. The new septic is going to be, you know, close to the property line. And the problem is the new well he just had drilled is only 5 feet off the property line. And that I feel like is an issue not only to him, but the upper Floridian aquifer, which is the type of well the gentleman has, serves, you know, thousands of people. It's all interconnected. I do have a bit of an issue with it, and I don't want to see this thing kind of get jammed up because we approved it here and then later down the line. So what I'd like to see is, I'd like to see potentially us get a measurement on that. If for some reason we decided to table this item, what would happen to this case? What would happen to this? Neither approve nor deny. What would happen to their case? Before we do that, I wanted to try to find out what's their timeline going to be.
So we've seen some applications tabled before, and
Zach, could you get closer to the mic? Thank you.
yes, ma'am. We've seen some applications tabled before, and essentially we would more or less just leave it as an undetermined until we get the documents back from the applicants that the board has requested, and then from then we would just schedule it for the next available public hearing. So if they can get the documents in, you know, 6 days, then we could come back next month. But if it's going to take them, you know, a few weeks to get boots on the ground and produce a document, then it may be into December or even January. But that would be completely up to the board on how to proceed.
The reason I'm going that direction is we went, you know, very in depth on this site plan. And correct me if I'm wrong, but I'm guessing even though they're right next door, DOH has probably not been in talks about this project. Is that correct? Or have they spoken to our department about that?
I don't believe we did any outreach to DOH
Okay.
on this request.
And I know it's a very particular case, and in no way am I trying to bash one individual or another, but I think reaching out to, on these tight lots, you know, when we're doing these applications, I know it's maybe not in our standard checklist, but on these tight lots, we run into issues like this where, you know, here, Dunn's Creek's another issue, which luckily they're going septic to sewer. But ultimately, we get issues like this where we're going to approve a variance, but then they're going to get down the road and realize, oh, no, we didn't realize that our offset measurement from septic to well is going to be, you know, too little. So what I'd like to see is that. So with that, I'll conclude and see if any board has any other comments.
Any comments from anybody else? I have an issue from the standpoint of, you know, if it's going to infringe on Mr. McKenzie's well, septic tank, it's just iffy. So, I'll let Ms. Wilson come back up and she can,
To rebuttal, Mr. Winkleman, that is just a concept of where we were just showing an illustration. That is not the exact proposed location of the septic tank at this point in time. We have not even measured that out. We haven't gone to DOH yet. That was just literally done at the 12th hour yesterday to see if we could possibly even make it conform in a 75-foot setback. So no, by any means is this the final site plan. We still have to do a drainage plan. We've still got some work to do. This was just kind of, like I said, a last minute, one of my guys said, this is what it could be. But by any means is this the final site plan that's going to DOH.
I understand completely. And by no means am I trying to create additional undue hardship on the applicant by requesting things that, we don't typically see, because we don't typically see this type of variance all the time.
Right.
But ultimately, you went in depth pretty far on the site plan as best you could. Do you see where I'm coming from as a board member, how your site plan and your where you have your septic tank currently placed, you could view it as, hey, this is where it's going to go. And also, just looking at the site, number one, even trying to get 75 feet off. So let's say you shift it to the front of the house.
Mm-hmm.
Right now, it's less than 75 feet, according to yourself and the applicant. So you can't shift it to the front, because then you would be less than 75 feet off the high water mark. If you shifted it to the other side of the house, over by the cul-de-sac, or in that general vicinity, it's your distance from home to waterfront setback is only 50 feet from the corner of the house. So ultimately, the way I'm looking at this is, and I know you're saying that's not 100% where it would go, that's the only place you can put it, according to this site plan and the way that I'm viewing all the setbacks.
Right.
So you run out of room ultimately on your high water mark, your high water line, on the setbacks on any point of one house that you get to. And I completely understand the applicant's hardship. They're trying to build a house. I'm in no way against it, but as a board, I'm looking at it from the standpoint of what best way can we make this work. So what I'd like to see happen is, again, I want that number. I want to know where that septic tank's going. I want to see you talk with DOH. For two reasons. Number one, that way we're informed as a board to make sure we're not creating undue hardship on the environment or other people because of the vertical separation between the neighboring septic and the gentleman's well at 123.
Mm-hmm.
And then also to make sure that you've got a little bit more duck in a row in regards to, you've now got to go to DOH and try and get their approval.
Correct.
You got to do that anyway.
Right.
So my point is, I'd like to see you talk with them, whether it be an informal or whether it be with staff as well, since they're aware of it. I mean, they are just right next door, fortunately. Have a discussion with them about your issue that you're experiencing and see if we can get a game plan down that better suits this. Because right now, there's too many uncertainties that ultimately could create issues for the community and also for discharge of sewage into the aquifer because of the setback issues you're going to have from neighboring wells.
Okay.
okay. Question, if this is tabled, how soon can you get those documents in order to be able to possibly get on the agenda for next month?
Honestly, I can't answer that question. We haven't even gotten into system design yet. We haven't made any contact. Again, this condition was just placed before us yesterday, so we kind of scrambled to try to get the condition changed to the state standard, which we obviously knew we would have to meet. But to be able to get all these documents, we have to go into a full system design to know how big exactly that system is going to be so we can lay out setbacks.
So you keep saying that you only received this yesterday. I got this a week ago or something.
I wish we would have had a little bit more time, but you can ask Michael.
Madam Chair, if I may, about 2 weeks ago when we had finalized the staff report and sent it to the applicant, at the same time, our computer system was crashing on us. Our email system was not sending emails properly to many different people, and we only found out weeks later. In fact, I would not have sent them a copy yesterday if they had not reached out to me, because I was under the assumption that they had received it 2 weeks ago. It was entirely a technical error there.
And Madam Chair, if it helps kind of give any sort of enlightening on this topic. If we got the documents by November 3rd, we would still have more than 14 days needed to mail out the notice. And then is it 10 days for a newspaper ad? And they run Thursday? They run on Thursday?
You're
Well, they
asking
run on
the
Saturday.
newspaper, it has to be
Yeah.
posted, right? I mean,
It's gotta be, well, the signs, we can do that the day we get the stuff. But if we get it on the 3rd, we would have at least 14 days for the mailed notice, and then we would have at least 10 days. We'd run an ad on the 8th of November, which is a Saturday. So we would be able to achieve the November 19th zoning board of adjustment meeting.
Mr., okay, you go ahead.
Yeah, I'm fine with that. I have a question for Mr. Perry. Mr. Perry? When tabling this motion, and if you've been hearing my reasons for it, ultimately, I don't want to create further undue hardship. Do you believe, without influencing my vote in any way, I'm not trying to gain that from you, do you think that I'm being unreasonable in any legal aspect of making a request of the applicant to provide further information to this board?
Mr. Winkleman, with all due respect, that's really not a legal question.
Okay, Mr. Perry, we can't hear you either.
I said, with all due respect, that's really not a legal question. You're a board member, you know what your responsibilities are, you have to take it upon yourself to make whatever decisions you think are right. And of course, you have other board members here that can discuss it with you, but what you've asked me is not a legal question.
Understood. Thank you, sir, very much.
May I ask a question?
Okay, Mr. Fisher.
I'm not sure, I don't know who to put it toward, but
Talk to Mike.
doesn't the state control that? I mean, don't they come out and look at where the other wells are? I don't know.
So that is correct. It is Department of Health, depending on the application. It could be Department of Environmental Protection, Department of Environmental Protection if it's for public supply. Michael Graves will chime in just a second on that. But ultimately, right now, the applicant hasn't had a discussion with Department of Health to determine if they can even gain the proper setbacks from neighboring wells, is my concern.
Okay, then, Mike, a question for you, is that something we should even be looking at? Because the variance has nothing to do with that, does it?
Mark, what you have to look at is what has been asked of you today. And
Right.
if you can do that, then you can take this, of course, it's up to the board. The board can table something for a particular reason. But if you're intending to, what the applicant has done is come in and ask for a specific remedy to whatever the problem, to whatever he's come to you with the petition. But as far as, as I sit here today, I don't know if the Department of Health is involved in this at all. I don't know if they've been to the property or not. All I know is that this board is responsible for what has been given to them, the problem that they've been asked to address. So, but it doesn't mean you can't table it, but obviously it's going to require some sort of discussion with the board members amongst themselves.
If I may, I do fear we may be getting a bit into overreach, as has been brought up by several of the board members here. Ultimately, what it comes down to today is the applicants are asking for a reduction in their setbacks more than anything. And there have been cases in the past where certain developments need to be approved both by the county and by a state agency, such as Department of Health. A very common one we get administratively is larger sized boat houses, which of course you need to get permission from St. John's Water Management District and Department of Health to build any kind of boathouse, especially larger ones. 90% of the time, the applicants will come to the state first and then to staff later, mainly because they don't realize we have a 600 square foot cap. However, there have been instances in the past where they have come to staff first to get an expansion permit, while they're either working with the state independently to get the permission to build that from the state, or they do it after us because they, for whatever reason, have chosen to do that because they know they want a specific design, and they know there's no point in bothering the state and going through with all that rigmarole if they can't even get the county to allow them to do it. Strictly speaking, it's not placing additional hardship on the applicant to say, okay, this is still contingent on what the state ultimately will let you do here. Ultimately, it's saying, okay, you've gotten permission from agency 1, agency 2 still needs to weigh in. It's very similar to how Development Review Committee works for commercial developments, where you can get through everything with development review for your zoning, your health, your fire marshal, but you still have to go through the building department after DRC, and that they usually don't say anything at the time of development review because there's nothing for them to say there. It's not placing undue hardship, it's just, okay, we're sending you off on to the next step. Staff does not have the ability to regulate health and safety and septic tanks, strictly speaking, because it is ultimately a state level condition. The board doesn't necessarily have that either, unfortunately. What we can, however, do is alter condition 3 there, as we had mentioned before, to say that it shall be located 75 feet away from the mean high water line or whatever the state allows for. And at that point, it is completely out of the board's hands, it is out of the county's hands, and it comes down to the applicants filing the proper paperwork with the state, as any other applicant at any other point would have to do.
Okay, thank you. Any other questions? Okay, at this point, we'll close it to the public and open it up for board motion and discussion.
Madam Chair, I'd like to make a motion. I move we approve variance number VAR 25-00008 as it meets the criteria for a variance as required by section 45-833 of the Putnam County Land Development Code with the conditions recommended by staff. The one condition that I would like to modify in my motion is condition number 3, reducing it from 100 feet to 75 feet to allow for the variance to be approved. Authorize the chair to sign the final order.
Is that 75 feet or what the state will allow for?
So the state, so you were referencing earlier, I see what you're saying. You were referencing earlier about what the state would allow for. So it would kind of we need to kind of delete number 3 altogether and almost make it where it's left up to the Department of Health is what you're recommending.
Relocated to a minimum of 75 feet or state allowance equivalent.
So Madam Chair, I'd like to amend my motion. I move we approve VAR 25-0008 as it meets the criteria for a variance as required by section 45-833 of Putnam County Land Development Code with the conditions recommended by staff, striking number 3 to state that the setback is to be 75 feet or the equivalency allowed by Department of Health state officials. Authorize the chair to sign the final order.
Second.
Okay, we have a motion and second to approve variance 25-000008 with the correction on condition number 3. So is there any further discussion?
Was there going to be any discussion about condition number 2 as well?
I'm sorry,
Was there going to be any discussion about condition number 2 as well? The applicants have requested that go from a 40-foot radius to a 40-foot diameter.
No, in my motion, there was no,
no.
and I'm not amending that. So,
Very well.
Yep.
Thank you.
Okay. Further discussion? We have a motion to approve, so all in favor, please indicate by raising your right hand. 1, 2, 3, 4, 5, 6, 7. All opposed? Okay. Motion carries 7-0. There is a 30-day appeal process, so with all of this that's been discussed today, please work closely with staff. And congratulations and good luck. Okay. Okay, the next thing on the agenda is old business. Do we have anything to discuss? New
Ma'am.
business?
Well, Madam Chair, I can't remember the last time we got to see you guys. I want to say it was in June, if I'm not mistaken. And I don't like to, toot my own horn, but Mr. Helms resigned in the beginning of July.
No.
Well, he's still a good buddy. I have lunch with him frequently. He went to the school board to pursue what his passion was and what he loved to do, and no one can fault him for that. Subsequently, I was offered the position of the Executive Director of Development Services. So I have fulfilled Mr. Helms' position, and I have made it through the ranks here in Putnam County. So, but that's pretty much the only new business that I got. But I wanted to advise you all so you know, I guess, the point of contact, should you have any issues.
Okay, and also in new business, well, good luck in your new position, too.
Thank you.
New business, we have a new board member, Cole Wilkinson. Welcome aboard.
Thank you.
Okay, anything else?
We have another one that wasn't able to attend, Mr. Michael Rayburn.
Oh, okay,
Yeah, we got two
two new ones.
new ones, yes,
Okay.
ma'am.
Sounds good. Okay, the next thing on the agenda is approval of the minutes for June, I think, 14th? June 18th. Everybody had a chance to read them?
Move they be approved as read.
Second.
All right, we have a motion second to approve the minutes for June 18th, 2025. All in favor, say aye.
Aye.
All opposed? Motion carries. Anything else to be brought before the board? Can we have
Motion to adjourn, Madam Chair.
Okay. We stand adjourned.